Pleadings. Pleadings are the formal documents filed in a lawsuit that inform parties of their claims and defenses that they have, that they're claiming to have against each other. Now, there are a few couple concepts that we need to talk about first. The first one is due process of law. We have this notion that it's not really fair to sue someone without telling them why you're suing them. Another way to say that is that's one aspect of due process of law. Due process of law is fairness. It's the proceedings that have to be followed before someone can be denied life, liberty, or property. Due process of law concept applies in both civil and criminal matters in all areas of American jurisprudence. And so pleadings are a very, very important part of that because it's through the pleadings that we notify the other side of our particular claim or defense. Joinder of parties. This is the notion that in a lawsuit that we try to include as many as is practical, as many claims and as many parties in the same lawsuit so that we can dispose of those claims, numerous claims, at the same time, just to be more efficient and avoid waste and duplication. Joinder of parties. What types of pleadings do we have? First of all, we have what's known as, depending on your jurisdiction, the petition or complaint. In many states and under the federal rules, the pleading that's filed by the plaintiff is called the complaint. In some states, like Texas, state courts, it's called the petition. It's filed by the plaintiff, and I'm using the pi sign here to indicate plaintiff. That's lawyer shorthand language. The answer is another pleading. The answer is filed by the defendant, indicated by the delta sign. And the defendant files the answer to contest the claim against them that's been stated by the plaintiff. Counterclaim. The defendant may say, well, I have a claim against you, plaintiff. And so it's in this counterclaim that the defendant states its claim against the plaintiff. Third party petition. The defendant may say, you know, this whole thing is really someone else's fault. It's not in the lawsuit. It's a third party that caused this accident or that should be held liable. So a third party action is filed through a third party petition or complaint where the defendant can bring someone that they say is liable, bring that person into the lawsuit. Cross claim. Two parties on the same side of the lawsuit may have a claim against each other. If you've got two defendants that have been sued by the plaintiff, one defendant may turn around and sue the co-defendant and say, no, it's really your fault. That is a cross claim. Then we have something called an intervention, and that's where there's a third party on the outside of the lawsuit that we're going to call an intervenor. That intervenor wants in on the lawsuit to protect a particular right or interest that they happen to have. So that would be an intervention. Then we have something that's, you don't see a whole lot, but it's out there. It's called an interpleader. And here the plaintiff or the person that's filing this interpleader, this type of action, is saying, I'm potentially responsible to multiple people and they're mutually exclusive. I'm either liable to A or I'm liable to B. I don't know which one. I don't want to pay off A and be liable to B. So I'm going to file an interpleader and we'll have a lawsuit to figure out to whom I am liable. Don't see that a whole lot, but it's out there. So what does this mess look like if everybody is suing everybody else? Now, not all lawsuits are going to be this complicated. Most lawsuits are going to be limited right here to the plaintiff suing one defendant, maybe a second defendant. And so I've noted this original claim in blue with the complaint, or depending on your jurisdiction, the petition being filed by plaintiff against a defendant one, and in this scenario, a defendant two. But defendant one here says, wait a minute, I've got, let's say this is an auto accident. And so plaintiff files against the commercial truck driver that they say caused the accident and the company he was driving for. And then the driver says, wait a minute, plaintiff, you caused the accident and I'm injured. So I'm going to countersue you for my injuries. Meanwhile, the owner of the truck, the trucking company, they may say to their driver or former driver, let's say they fire him and they say, you really caused the accident, you were drunk while you were driving, we're filing a lawsuit to recover the damages to our vehicle. You know, you can make up all kinds of scenarios, but I'm just giving you one. As all these people are filing their claims against each other, notice that the person against whom the claim has been filed is filing an answer back. Plaintiff files a suit against defendants 1 and 2, they both file an answer. Defendant 1 files a counterclaim. It's assumed that plaintiff is going to contest that, so you generally don't see an answer going back, but you may, depending on your jurisdiction. The cross claim, there may be an answer coming back here to deny that. Defendant says, wait a minute, the accident was really caused by the mechanic who didn't properly fix the brakes, so we're going to sue the mechanic over here. Bring in this third party through a third party complaint. Well, the third party, once they're served, they're going to file an answer and go back. You may or may not have someone on the outside that's maybe another motorist that was injured or someone that was injured in the accident. They say, hey, I want in on this too, and they may move to intervene. And then, of course, in response to that, whoever they're suing is going to be filing an answer, probably a denial of some sort, back to them. So it can be very complicated, but rarely is. Parts of a petition or a pleading. The top of a pleading, papers that are going to be filed in court, that even includes discovery matters, but certainly for pleadings, the top of it is what we call the caption, and the caption will have several components to it. The first is going to be the style of the case that announces or labels the parties. John Smith versus Bill Jones. Or if it's a probate matter in the estate of John Smith, something like that. So that's going to be the style of the case. It's also going to have the docket number, sometimes called the cause number or the case number, but that's going to be listed after it's been filed, of course, because it'll be the court clerk that assigns a docket number to it. So as we prepare these in the law office, obviously, we don't know what the docket number is going to be, and we just leave that blank. And same thing for the court. We generally don't know what court it's going to be filed in unless you're in a small or rural area where there's really only going to be one court where you're going to be filing. But the court designation is also going to be in that caption. Then we have a body of the complaint. And here is where the cause of action, the reason for the lawsuit, the basis for the lawsuit is explained. And it's going to include that body is going to include several components. In many jurisdictions, particularly federal court and many state courts will require the court's jurisdiction or the basis for the court's jurisdiction to be set out in the pleading, why you're filing the lawsuit in that particular court or that type of court. The claim is to be stated in plain language. No fancy legalese is allowed. And some judges have their own local rules that even make that more simpler and more to the point. Relief sought. Do you want money damages? What kind of money damages? Compensatory, exemplary? What do you want? You want an injunction? That will be set out in the body. And we have two types of pleading here. We either give enough, we give all the facts that are needed to prove our case, and that's called fact pleading, or we simply plead or give notice of sufficient facts so that the opposing party knows what we're talking about. Most jurisdictions follow notice pleading. It's much shorter. And then the last thing in the pleading is frequently called the prayer or the request for relief, demand for judgment. And in many jurisdictions, it may commence with the word wherefore. Plaintiff requests such and such. Okay, and that's going to be the last paragraph in the pleading. A word about the parties. The parties, we know, as we've said already, the plaintiff brings the lawsuit. The defendant is the person that's being sued for the alleged wrongdoing. Okay, that's the obvious stuff. But let's talk a little bit further here, because the plaintiff has to be a party in a real party in interest. They have to have a right under the law to sue. They have to have what we call standing to sue. That means they either have suffered or will suffer a real or direct injury over the alleged wrongdoing. And then the parties have to have capacity. They cannot be an incapacitated person that's filing or defending the lawsuit. If someone is incapacitated or suffering under some sort of incapacity, but whether it be because of lack of age or lack of mental capacity, that person has to be represented either by a court-appointed guardian or what we call a next friend, someone who has stepped up and said, I will represent you, and which of course the actions of the next friend will be, particularly any settlements, will be subject to court scrutiny, since that person has not really been appointed as a guardian as such. Okay. And then we'll have attachments that are frequently attached to the pleading. You may see a verification. A verification is a brief affidavit that states that the facts stated in the pleading are true and correct. Whether that pleading is a petition, complaint, answer, counterclaim, if you need a verification under the law, that is frequently found there. Exhibits. It may be useful for the party filing the pleading to attach a copy of the contract or the copy of a deed, if that's what is the subject of the litigation. Or maybe it's a promissory note that hasn't been paid. So it's not unusual to see attachments such as those included in the pleading. Certificate of service. The party or the party's lawyer is going to sign a very brief statement that says this is to certify that the foregoing whatever pleading it was, what was transmitted to, delivered to, sent to all counsel of record or all parties or something to that effect, certifying that, yeah, we sent this to everybody. Everybody is getting this. Proposed TRO or injunction, if a party is seeking a TRO, then it's quite normal to attach the proposed TRO, to temporary restraining order, or the proposed injunction to the petition or complaint, as the case may be. And then, of course, what may be called a show cause order or a notice of hearing, an order from the court or the clerk, or a notice from the clerk, or maybe even just from the lawyer saying a hearing will be held on this. Or if it's a show cause order, an order by the judge saying you are ordered to appear and show cause why the court shouldn't take certain actions. You particularly see that sort of thing with regard to a TRO. And that's a view of what pleadings are all about.